I would like to say good evening and thank you everyone for joining us for tonight's panel discussion called The Anatomy of a Murder Trial, the Derek Chauvin Trial for the death of George Floyd. On behalf of the Bethany community and the legal studies program here at the college, we welcome you. My name is Sarah Edwards. I am an attorney and I also am the head of the legal studies and paralegal programs here at Bethany Lutheran College. And I will be your moderator for this evening's event. Before I introduce our illustrious panel, I would like to describe our purpose here tonight and how we're going to structure this discussion. We are here to inform people generally about the criminal trial process and specifically the process involved in the Derek Chauvin trial for the death of George Floyd. We are not here to determine guilt or innocence or the merits of one side or the other, or to come to a conclusion on a verdict. As we all know, this case has brought worldwide attention to Minnesota and specifically to Minneapolis. The outcome of this case will inevitably have a powerful and lasting impact on issues involving social justice, race relations, protests, and police brutality. So what we're going to do is spend the first 45 minutes discussing the criminal process and the trial, and then what we will do is take the last 15 minutes to respond to audience questions here in the room and online. So if you have questions along the way and you are joining us virtually, please feel free to put them in the chat, and I will be checking them periodically and selecting questions that I think the panel might be able to provide some insight on. So I would like to introduce you tonight to our panel. The first person I'd like to introduce is Paul Gunderson. He's going to provide our prosecution perspective tonight. Paul is a Bethany alum, and he serves as one of Bethany's mock trial coaches, thankfully. Paul has served as the assistant county attorney in Brown County for several years, where he prosecuted serious felony crimes. He's a graduate of the University of North Dakota Law School, and he is currently an attorney at Blethen Barron's Law Firm in New Ulm, Minnesota, where he practices in the areas of general civil litigation and criminal defense. The second person I would like to introduce, although not in order, Dan, you're out of order, but Ryan Drea at the end will be providing the defense perspective. Ryan also graciously serves as one of our mock trial coaches here on Bethany's campus. He is a graduate of William Mitchell College of Law. He served as a clerk at the Ramsey County Public Defender's Office in the 2nd Judicial District. He also served as the student body president at Mitchell-Hamlin, then William Mitchell, and volunteered 500 hours with the Minnesota Justice Foundation. After law school, he started a law firm and practiced mostly in criminal law and dabbled in civil litigation and estate planning as well. In February 2015, he joined the 5th Judicial Public Defender's Office, starting in the Worthington office and then moving to the Mankato office, which is where Bethany Lutheran College is located, if you didn't know, where he remains this day and has handled cases ranging from shoplifting to first-degree murder. Ryan wants me to add that he enjoys traveling with his wife, Hannah, in his free time. And of course, he loves coaching the mock trial students as well, and travels with a wonderful border healer. I'm not even sure what that is, but her name is Maddie. So, and then finally, last but certainly not least, is Dan Birkholz. Professor Dan Birkholz serves here in the legal studies and paralegal programs as well. He teaches courses in criminal law, criminal procedure, and evidence, as well as many others. He is also a Bethany High School alum, a Bethany Junior College alum, and a St. Cloud State alum. He also went to law school in the University of Denver. He served as Watonwan County Assistant County Attorney from 74 to 76, Watonwan County Attorney from 76 to 98. He has been a criminal defense attorney since '98 up to the present, and he has been in private practice. He has prosecuted everything as well from shoplifting to first-degree murder, and has defended primarily drug and sex cases, and lost only 2 felony jury trials in 24 years. So I would like to give a round of applause for our illustrious panel and thank them for joining us tonight. All right, so we are going to start from the prosecution area. And so, Paul, before we do that, actually, I would like to have Dan give us a brief rundown, of our the criminal trial process. Dan, maybe you can just give everyone who is unfamiliar with the criminal trial process a brief overview so that when Ryan and Paul speak, they will have a little more context.
Sure. There are two basic trials in the criminal justice system. There are trials to the court or to the judge, where the judge makes the decision of guilt or innocence, or jury trials. We're most familiar with most criminal cases are tried to juries. In felony cases, there's 12 jurors and usually 2 alternates. And any verdict in a criminal case has to be unanimous. So if there's 12 jurors, all 12 of them have to agree on the issue of guilt. Not necessarily on innocence. If they agree that the state has failed to prove their case, they can find for what's called an acquittal and have the charges against the defendant dismissed. The prosecution, the county attorney in the state of Minnesota as a prosecutor, they go first and they present their case first. The defense follows the prosecution case and they go secondly in the trial process. The witnesses that the state calls, or the prosecutor, the state puts them on for what's called direct examination, and the defense attorneys have the right to cross-examine all of the state's witnesses. And when the state has rested their case, then the defense has the right to put on witnesses and have them testify on behalf of the defendant. The defendant does not have to testify. That's a choice the defendant has. Neither the court nor the prosecutor can comment to a jury that a defendant fails to testify. That would be reversible error. And so the defense has the right to call the defendant. My experience has been, in both criminal prosecution and defense cases, the juries want to hear from the defendant. They've heard the prosecution's case, and they're usually quite attentive to prosecutors. Juries tend to be reasonably conservative, but they really do want to hear from the defendant, and they want to hear the other side of the story. So when I take criminal cases, I always start with the client and tell them, look, if you want a trial, you're going to have to testify. Otherwise, it looks like you got something to hide. Okay? And the juries want to hear the whole story, so I always tell them, plan on it. Plan on testifying, because I want them to see you, I want them to hear you, and if you're really innocent, then you need to tell them you are innocent so they can hear that from you, not some lawyer standing up and telling the jury you're innocent. When the case is completed and all the witnesses have been called, we have closing arguments, and after the closing arguments by the prosecution and defense are completed, the judge reads what's called jury instructions, which are pages long, some cases 20 or 30 pages long. They read them to the jury. Some judges, I think most of them now, at least the ones I've seen, will actually let the jury take the jury instructions with them into the jury room along with the evidence that's been offered in the trial. And then the jury is not the judge. The judge makes legal rulings during the trial on legal issues and procedural matters. It is only the jury that reviews the facts, and the case is supposed to be decided on the facts they have heard in that courtroom and only in that courtroom. Not what they read in the newspaper, not what they heard on the media or on their cell phones, but solely based on that evidence, and they make the decision of guilt or innocence. That is a really quick summary of jury trials that can last weeks.
Very good. Thank you so much, Dan, for that overview. So I'd like to start with Paul tonight, and maybe, Paul, you can talk about what the charges are against Derek Chauvin and what the prosecution has to show.
Sure. And I'll take this off as well for this portion. There has been a lot of issues, a lot of wrangling ahead of the actual trial, more so than any other case it usually has for this particular case. There are 3 charges that are currently asserted against Mr. Chauvin. Those are second-degree murder, third-degree murder, and then second-degree manslaughter. But the interesting history here of the case, even though it's approximately a year old or so, is that it started off with a different charge when the Hennepin County Attorney's Office charged it. Then there was another charge added, the second-degree murder was added when the Attorney General of the state of Minnesota was added to the case or took over prosecution. And then a judge dismissed the third-degree murder charge kind of midstream before it even got to the trial, and that went up to the Court of Appeals. Very fascinating history, I guess. Usually does not happen that way. Usually you have a simple document called a criminal complaint, and a prosecutor looks at the evidence that the investigator has collected, the police officers, so forth, and they make a charging decision. There aren't usually appeals ahead of a trial. That usually takes place afterwards. So all of those things make this case very, very unique. So as to the actual charges, the second degree, well, first of all, I guess, when everyone thinks about this case or any case where there's a death, you often think of intentional type of acts. Someone is murdered because another person wanted that result. That's not what the prosecution is even alleging in this case. There's no premeditation. Nobody thought about causing the death of another person before these events occurred, at least as the prosecution is going to try to prove. The charges aren't even intentional. So the top count is second-degree unintentional murder. And the language of the statute actually says that the individual did not intend to cause a death. The intentional part is that they needed to have committed a felony, and those acts, while they were committing the felony, led to the result of a death. Okay? So what are the felonies here? The most likely theory that the prosecution will use is some sort of assault. In Minnesota, the 2 felony assaults that are most common are going to be third-degree assault, which is when you commit a substantial bodily harm to the other individual, or second-degree assault, where you use a dangerous weapon, oftentimes a firearm, not in this case, but a dangerous weapon to assault another, okay? So that's kind of the top charge, the second-degree murder. The second charge, and this is one where there's been a lot of maneuvering, is the third-degree murder charge. And that is where you cause death through actions that are eminently dangerous, and you as the actor are evincing a depraved mind. A lot of legal jargon there. The idea here is that the acts that were committed were not intentional, but they also were not negligent. That negligent charge is actually the second-degree manslaughter. That's the third one, or something similar to that. This third-degree murder charge is actually a reckless act. So it's somewhere in between those intentional acts and a negligent act. This is the charge that was actually dismissed. And Judge Cahill considered arguments related to whether or not someone could be charged with a crime when their acts were only directed at a singular person. There's language in the statute that says others. And that, at least by some, was interpreted to mean that your actions have to be reckless, evincing a depraved mind to all sorts of people. So not just Mr. Floyd. So on that basis, Judge Cahill actually dismissed on probable cause grounds. That means that the defense attorneys argued, even if the evidence as presented at this preliminary stage is true, you still cannot prove that particular charge. He dismissed on that basis, and that was appealed. There was actually another case, the state of Minnesota versus Muhammad Noor, that was going on at the time up on appeal with not necessarily similar facts, but it was also a police officer, also a charge of third-degree murder. And that particular argument by the defense attorneys in the Muhammad Noor case was actually rejected by the Court of Appeals. So this all happens while the Chauvin case is on pretrial, and there's some back and forth between the Court of Appeals and the district court. The end result being the Court of Appeals says that the Muhammad Noor case is binding precedent and you need to consider it, because Judge Cahill had said, it's not binding precedent, I don't need to consider that. So actually the day of, or I think maybe the second day of the trial and choosing a jury, we now have a third-degree murder charge back. That usually doesn't happen. All that stuff that I just related definitely doesn't usually happen, so it makes this case particularly unique. So why does that all matter? Well, the different penalties for each of those crimes are more severe. The second-degree murder is 40 years maximum penalty, the third-degree murder 25, and the second-degree manslaughter, I believe, is 10. So if Mr. Chauvin is convicted of any of those counts, the potential penalty could be drastically different. And that's why there was so much wrangling, so much argument over what he should be charged with in the first place. I guess that's a fairly brief explanation of the charging part of this.
Okay, very good. And maybe you could convey to the audience what the burden of proof is in a criminal trial if they're unaware of what that is.
Oh, sure. So the state has to prove the charges beyond a reasonable doubt. So that's more than for your civil cases, which is more likely than not is kind of the common lingo there. But it's the highest type of burden that the legal system has.
Okay, very good. All right, and I think what we'll move to now is Ryan Drea. Okay. And kind of what the theory of the case is for Derek Chauvin and the defense.
Thank you. All right, so as I tell the mock trial students, when you're a defense attorney, your job isn't to disprove everything that the prosecution is trying to show, but rather to raise reasonable doubt, which Paul just, explained. Reasonable doubt is just essentially more likely than not, this is what happened, okay? Now, in order to raise reasonable doubt, the first thing I do as a defense attorney is when I'm preparing for trial, I take out the statute book and I take out the jury instructions that Mr. Birkholz referenced. And I look at them and I say, okay, if I'm going to prove that my client didn't do these things, where can I find the holes? Now, when it comes to Derek Chauvin and the death of George Floyd, what it comes down to is, was Derek Chauvin some way responsible for that death? Each and every one of the charges, whether it's the second-degree murder or the second-degree manslaughter, he has some type of responsibility for those actions. So looking through the evidence, and I don't have access to all the evidence because I'm not one of his defense attorneys, so I have the same access all of you do, which is what the news media reports, what I can find online. But looking at the evidence, the big thing that sticks out to me is that the coroner's report lists the cause of death as homicide, but its homicide is cardiopulmonary arrest while being restrained by a peace officer. He had a heart attack. Now, the other interesting thing about the coroner report, it also mentions a couple important things about George Floyd. First, it notes that he has a history of both high cholesterol and high blood pressure. The cholesterol has actually progressed to the point that it's advanced to arteriosclerotic and hypertensive heart disease. So what that means is that his veins and arteries are clogging. So you add that in to the fact that he was in a high-stress situation, regardless of whether or not there was a knee in his throat, and that could be enough to cause a heart attack. In addition to his medical issues, in his blood, the coroner found both methamphetamine and fentanyl. Now, for those of you who are not avid users of illicit drugs, which I would imagine most of you aren't, methamphetamine is a stimulant. People who regularly use methamphetamine will stay up for days, sometimes weeks. It stimulates the system. It is not going to be a good thing for someone with a heart problem to have in their system. Fentanyl is what killed Prince, causing a heart attack. Where the defense will likely focus during this trial is the fact that George Floyd had a heart attack, not because of the actions of the police officers, but rather his medical history and his drug use. You're going to hear a great deal of testimony regarding those two things. Likely the prosecutor or the defense attorneys will bring their own expert witness to talk about those specific things. It'll be another coroner, not from the same office, but they'll review all the same documents. They'll come to their own conclusion, and that conclusion will likely be George Floyd died of a drug overdose because of his underlying medical conditions. Now, to be sure, there are some very troubling things that the defense is going to have to overcome in this trial. One is the video that everybody has seen. That video showing Derek Chauvin holding his knee on George Floyd's neck for nearly 9 minutes. 2 minutes after he was told that he no longer had a pulse. That is going to be a very high hurdle for them to get over. And that, in my opinion, is why the state charged out 3 different charges. They charged it out because they know that if the prosecution can can raise reasonable doubt, rather, just based on the fact that he had this medical history and he had this drug history and all that's in his system, there's still the fact that he created an unreasonable risk by keeping his knee there for 2 minutes longer than he should have. Probably more than 2 minutes longer, because I'm assuming that his heart stopped beating long before they checked his pulse. So finding their way around that unreasonable risk, that's the other hurdle that they're going to have to get around. How they do that, well, I would normally anticipate that they're going to bring in information about George Floyd's prior arrests, his prior history, any violence in his past, any reason that the officers might be concerned. The big problem there is the video that they're going to show. There's 2 videos. There's the one that goes around social media, the one that we've all seen. And then there's the body cams worn by the police officers. The police officers who came to the scene, they were called there for a counterfeit $20 bill. They were instructed where this gentleman is. They went to his car. They pulled their guns and got him out of the car. But he didn't resist. He got out of his car. They arrested him without any problem. They put his hands behind his back, told him he was going to be arrested for passing counterfeit money, and started walking to the squad car. He was calm, cool, and collected. I would imagine the prosecutor is going to talk about that at great length, because George Floyd's doing nothing to warrant what happened to George Floyd. There was a ruling earlier this week in this case where the defense attorney asked to bring in evidence of a prior arrest of George Floyd from last year. That arrest would have gone to his drug use. It would have shown how he used drugs, as they found drugs in the squad car after George Floyd was in it. It would have shown his tendency to resist, as he did here. But more importantly, it would have put a different light on George Floyd. The judge said the only thing they can use that for is proof of his medical history. So they don't get to show whether he resisted, whether they found drugs, just proof of his medical history, because he was taken to the hospital that time too. So it'll be good in that way that he was taken to the hospital because of medical problems. And it'll help bolster the fact that, hey, maybe the cause of death wasn't a knee to the throat, but a heart attack caused by a long history of medical issues, and combine that with drug use. No doubt this is going to be a difficult trial for both sides. In part, for the defense, because they have all these charges, and there seems to be a judge who is trying to be as fair and impartial as possible, but at the same time is aware, as we all are, of the national ramifications this has. And that weighs on everybody. And that's what's going to make this a very long and difficult trial. As far as strategy goes, the strategy is simple. You got to take the culpability out of Derek Chauvin and put it into his health and his behavior. That's what the defense team will try to do throughout this trial.
All right. Ryan has alluded a little bit to sort of the best evidence for the prosecution, which would, of course, be the video. But maybe Paul can illuminate a little bit of what some of the other strong suits for the prosecution might be as far as Derek Chauvin and his past history as a police officer. Maybe you could comment a little bit on that, Paul.
Yeah, and I guess I'm not aware of what the judge has ruled, if anything, related to that history. Obviously, if Mr. Chauvin has a history of treating individuals this way, that's not going to shed, I guess, positively on him. But I guess I'm not aware enough about that history to provide a lot of comment on that.
Okay.
I can mention a couple things that I know.
Sure, Dan, you want to jump in?
Chauvin has a history of using excessive force, and there were complaints filed against him, and I can't remember the number of them, but there was like 5 or 6.
17.
And he's also
17.
been-
There were
how many?
17.
17,
Oh, whatever. I was
including one shooting.
Yeah, right.
That resulted in a
And he's
death.
also been, he has been involved in using his firearm. And so I think the fact that those things happened are true, but that's not what this case is about. It's only about George Floyd. So even if Mr. Chauvin used excessive force against a grandmother in a grocery store for shoplifting, how is that relevant or related to what he did to George Floyd on that particular night? The problem we're getting, and this is to me unfortunate, but it is, We're getting so much information about so many people, particularly from media and the social media, about almost entirely Derek Chauvin and the three officers. They're the focus. Everything else is really not relevant to the media because it sells papers and people like to read about bad cops doing bad things to good people, okay? And I'm going to say this now before somebody says I can't, but this case is not about social justice. So everything in the paper, including 60 Minutes last night, I finally shut it off. It is not a social justice case. The law in the state of Minnesota on second-degree murder, third-degree murder, and manslaughter is gender neutral, it's color neutral, it's religious neutral, sexual preference neutral. It has nothing to do with race. The law does not. There are race crimes of bias and religious bias and so forth, but not murder. The law is colorblind on these three counts, period. Okay, I don't care if Chauvin was black and the defendant was, or the victim was white. It doesn't matter. But that's not what the media is doing to this case. Okay, and they are making it a race case, and social justice is supposed to change based on the outcome of this case, which if you're reading social media, we already have people planning to protest and to riot if they don't get the verdict they believe is fair. Now, my question to you as 12 jurors, at least 8 of them here in the room tonight, how can you make the decision of what's right or wrong when there isn't a single person in this country that has heard one witness testify? You have no facts that are going to be heard in that courtroom because we haven't had the court trial yet, or the jury trial yet. The jury only can reach a decision on what's said and shown in that courtroom. Why are we talking about protests and riots? Sorry, I think we're premature. That's not how our system of justice works. We have an executive branch, a legislative branch, and a judicial branch. We're dealing with judicial branch. Judges do not make legislation. They don't make law. They're supposed to follow the law. Okay? And I think you have to keep that in mind, even in this case, that this is about, did a murder or a manslaughter case, was it actually committed, and did the state prove its case? Okay? I think you're going to see a split verdict here. I am going to be stunned if they convict him of second-degree murder, third-degree murder, and manslaughter. I think juries have a history of splitting the baby, if you will, saying, well, I don't know if he did second degree, but, well, maybe third and possibly manslaughter. I think it's very likely you're not going to see 3 convictions, and you may see 1, possibly 2, but I doubt 3. I just don't see the jury doing that, okay? And you have to be prepared for that. Now, if it's not the verdict you want, is justice not been done? That's the issue, and that's going to be very personal, but that's not how the court system works. If you like the verdict, fine. If you don't like it, fine. But the jury made that decision, okay? They're the ones that have to make that call. And you can like it or you can dislike it. If you don't like it, is there a miscarriage of justice? And if you like it, was it a fair result? That's your problem, not mine.
Well, picking up on the issue of a jury, I think today the last juror was selected. And so maybe that should be our next point. Maybe you guys can talk about, when you have been part of a jury selection process, what are you looking for? What are you not looking for? How do you deal with peremptory strikes? And maybe you can provide some insight on that.
One particular thing I guess I'm looking for when I'm choosing a jury is who's going to be a leader in the room when they take all the evidence, the jury instructions and so forth. That jury foreperson tends to be a very instrumental individual. They tend to sway sometimes the jury to go one way or the other. So that, I guess that's one thing that I would be looking for. Obviously, the demographics and makeup of a jury are very important. I think they're very important in this particular case. As Mr. Birkholz was just talking about, the social justice implications of the trial obviously are at the forefront of everybody's minds. So I'm going to want to probe into what types of information has the jury received prior to the trial? And then are they going to be able to set aside any preconceived notions that they might have? Because at the end of the day, we're all supposed to be trying to find a fair and impartial jury who's going to consider the evidence and render a fair verdict. That becomes particularly difficult in this case when there's been so much pretrial publicity. So I guess that's my comments, but everyone here has had a lot of experience choosing juries.
Go ahead, Ryan.
So the part about jury trials I hate the most is picking the jury. So I don't think there's an attorney that you'll meet that say, the best part about jury trials is I get to pick them. No, because the popular conception of you're picking your jury isn't what happens at all. You're trying to eliminate the people you think are going to be the worst for you, but you're not necessarily getting the entire pool of people either. So in a typical jury trial, what would happen, and it's a little bit different than what happened here, okay? But in a typical jury trial, what will happen is you'll have 12 people sitting in a jury box, and the judge and attorneys will, in turn, take turns asking questions of the entire panel that are in the box. And as they answer those questions, then the attorneys will have the option to strike them or keep them. And once there are 12 people agreed upon by all the sides, you have your jury. Now, here in Blue Earth County, where we're at, the typical jury panel that they're going to bring in is going to be about 30, maybe 40 people, okay? For something like this with George Floyd, I wouldn't be surprised if they had 100 people waiting in the wings. Now, they did it a little bit differently with this case. They did what they call what's called individual voir dire. So instead of having all the jurors in one time, they had them one-on-one. And they got to spend as much time as they wanted asking that juror question after question after question. Before the jurors even arrived at the courthouse for their first day of jury selection, they had already filled out a jury questionnaire that was sent to them probably a month prior to trial. That questionnaire asked them their opinions on all the social media stuff we've alluded to here, the Black Lives Matter, the Blue Lives Matter. It asked them questions about protesting and their general opinions on police officers. I saw someplace, I want to say the questionnaire is about 30 pages. Now, some of that's just biographical stuff, age, race, occupation, whether or not you're married, if you have kids, how many, how old are they, that kind of thing. But they really tried to, in that questionnaire, figure out which people they're going to want. Well, I should take a step back. That questionnaire is then provided to the attorneys who go through it and try to find the people just based on that questionnaire who they think are going to be good, bad, or that they really want to hammer on questions. So if they responded to, what are your thoughts on Black Lives Matter, and they had something way far on one side of the political spectrum or way far on the other side, the attorney is going to take note of that, and they're going to ask about it. Because as Mr. Gunderson said, what we're all trying to do is find the most fair and impartial jury. But this case, that's very difficult.
Can I say one thing?
Dan, feel free to jump in, yes.
Please, thank you. I didn't really care if they were fair or impartial. I just wanted them to believe me. All right.
Right.
When I was prosecuting, my goal, and in theory, okay, fair and impartial, that's a nice idea. But I wanted them to believe that me and my witnesses were telling them the truth. And I wanted them to like me. Okay? Here's why. This is on our cards we use to give to clients. A jury consists of 12 persons, chosen to decide who has the better lawyer. It
Dan,
works.
that's so bitter.
It works. I have seen, I handled a case for another county one time. I prosecuted. The defense attorney was arrogant, he was rude, he was obnoxious, he interrupted the judge, he interrupted me constantly, and the jury hated him. And I'm saying, I just have to stand up and say he's guilty and I can sit down. Okay? So that's sort of, but yes, you want to be fair. You don't want anybody, I don't want anybody with a bias, one way or the other. Just saying, I'll listen to the evidence and be fair, that's close enough. Thank you. And
Thank
of course,
you.
then we get rid of the ones we don't like.
Thank you, Dan. It's about 15 minutes to, and we have a question from our audience, which is the online audience. Do you think that the settlement that was announced in the George Floyd trial, awarding the family $27 million, impacted the jury? And how?
Who asked the question, first of all?
Somebody online.
Oh, online.
Yep.
So,
Hello? What's your next question? All right, no, go, somebody answer
yeah,
that. Go
you know,
ahead.
I can't see how it wouldn't. You know, I mean, you're in the middle of jury selection, and the city announces, we've decided that we have a level of responsibility to the tune of $27 million. I don't know how that can affect the jury.
I agree.
Matter of fact, 2 people were dismissed off the jury because of it. So,
Well, it's an admission of fault by the city, the officers did something wrong. Now, if they did 27 million wrongs, how do you view Derek Chauvin now when he walks into the courtroom? I was upset that that happened. It was blatantly unfair. The city has their attorneys, the prosecutors have theirs. And no one's going to tell me the prosecutors and the city attorneys didn't discuss this before they released that information. The city can make any settlement they want. Frequently, they're confidential. So it could have been confidential and everybody could have been happy spending their $27 million. But to release to the public the dollar amount during the jury selection was a absolutely unforgivable sin, if you ask me. And if the prosecutors knew that, they should have told them, settle the case, disclose the amount after the trial and say, we'll tell you, but wait till the trial's over. That would have been the appropriate way to do it. It was blatantly unfair to every defendant in this case, not just Derek Chauvin, to be told that. Yes, we have a question from the little girl in the back.
Professor,
Yes.
do you think that they did that intentionally to sway the court case one way or the other?
They're going to absolutely deny that, but that's exactly what they did.
For those of you at home, the question was, do you think that they did it intentionally? Kyle, you have a question?
Similar to what Caroline asked, the threatening of the rioting and protesting, if the jury doesn't find in favor of what the people want them to have, is that also good? Is that something that they're going to try to do to sway the jury to find Mr. Schroeder guilty?
Because there might be riots?
Yes.
Well, you want to take that one?
Well, I don't think you would hear that expressed during the trial. That would probably result in a mistrial if either side tried to argue that. I suppose there's ways to bring up those facts without actually saying it. But that's going to be the basis for an appeal if anyone tried to mention that type of argument during the trial.
See, I think the fact they did it's a basis for appeal already. As Judge Cahill said after that came out, the defense brought a motion for change of venue to another jurisdiction, and Judge Cahill quite accurately, correctly said, there isn't anyone in the state of Minnesota that is immune from that knowledge anymore, so I'm not going to give you a change of venue because I can't change the damage. Literally, he's saying I can't change the damage that's been done. And he's right. But I think it was blatantly unfair.
All right, Bella, do you have a question?
I can ask.
Oh, sure, go ahead.
This is like, it's kind of a change of topic. It's back to the voir dire. Anybody who's been following this case, especially the judges come out and he's done a lot of explaining of the voir dire, especially since they've been individualized. I guess like I'm so young, I've never this is the biggest case I've ever seen, especially coming from Minnesota. Do you find it weird how much has gone into like the voir dire and like the breakdown in the media of the jurors who have gotten on? Because like every day it's like it'll, basically what I've seen in the video, it'll start out who they are, what their age is, what grade. And like, really get into it. Is that like normal for the media to do, or?
So for folks listening online, if you weren't able to hear that, just encapsulated, Bella is asking if the current publicity over the jury selection is something that's normal, and particularly regarding their age, race, gender, and whether that's something you've seen before.
I would say, yeah, it's very abnormal. I've been involved in high-profile cases, and all the media reported was the jury selected, or, they selected 3 jurors this week, or this day, but they didn't give the stats. So, yeah, I found it, when I was looking in preparation for tonight, when I was looking at some of the media, I was rather struck by the fact that they're giving so much detail about the people that are deciding this case.
Unique to this case also is that individual voir dire that Ryan talked about. So there's more information about the jurors, because typically you're asking questions of an entire panel. You might get a little bit of an insight into that particular juror's background. But in this case, you're spending minutes, hours with a specific juror, and that's why the media has that much information. The most I've really seen is usually, this many women, this many men are on the jury, while you're still in the actual trial phase.
If you were in federal court in a major drug case, and I mean a major drug case, you will find that the jurors' names are not given, addresses, they're given a number, and they are not required to divulge personal information about where they work or where they go to church or anything like this, simply for the safety of the jurors. And what if the jury comes back with a verdict that is not liked by a lot of people? These jurors now can be targets of the rioting, they can be targets of death threats, they can be targets of hate crimes themselves, and that's a risk they're taking. So I think, like Ryan, it's very unusual that they're doing that.
Yeah, today I wrote it down. The Star Tribune has a live stream of the jury selection, and we'll have live stream of the trial, which will be our next question that someone has asked us. But right now, the current makeup is 15 people have been selected, 6 men, 9 women, 8 white, 4 black, 2 are multiracial, and 1 refused to identify, apparently, a race. So that is what the next question is, which is from the audience online. Can jurors be excluded by race?
No.
No, the answer is legally no, practically yes. Happens all the time.
Okay, legally no. You might want to say that in the microphone, Dan.
Oh, I'm sorry. Yes, right. There are cases all over the country where, especially if you go south into the south part of the United States, there's a long history of minorities being excluded from juries, not just blacks, but Hispanics and Asians and others as well. And so, does it happen? Yes. Is our system flawed? Yes. Is there racial bias by police officers against minorities? Yes. Let's start with that being true, and then just hope that our criminal justice system that we have with the use of judges and lawyers can sort out those problems prior to the trial beginning and get a fair and impartial juror that is appropriate for the cases that we have to have. But if you look in Minneapolis, Atlanta, Detroit, Chicago, it routinely happens that minorities are systematically excluded. Now, as a good lawyer, you can come up with other issues like, oh, you've been arrested for a DWI. So, and this is a DWI case, so I don't want you on my jury. And the fact that they're black doesn't matter. You're simply, well, I didn't excuse him because he's black, but he had a prior criminal history. I don't want prior criminals on my jury. So it can be done, and if you're good at it, you can be quite effective.
Right, and there was a specific Supreme Court case that addressed this issue and made that an unacceptable reason to exclude jurors, but as Dan mentioned, sometimes that in practical terms happens. Tristan?
I have a quick question before I have to run over to the student senate speech next quick, but this was about something that Ryan brought up earlier. in a case that involves a victim that has like a pre-existing condition like Derek Chauvin, high blood pressure, high cholesterol, things like that, where do you draw the line between the murder being caused by the intent or the action of the officer and by that condition? Because obviously the actions of Derek Chauvin exacerbated that condition, but at the same time, you could argue that if that's a different person, that wrongful death isn't happening at all. So where would you say, I feel like that's a very difficult thing to determine.
The question that Tristan had was about where the line is between the underlying health conditions that George Floyd had and where the intent or the transferred intent maybe from Derek Chauvin to George Floyd might have, crossed that line. I don't know. Anybody can answer that.
So I think really that is what the defense's job is to show that the cause of death wasn't Derek Chauvin, but these other things. That is really what's going to be at heart in a lot of the arguments for both sides here. The prosecution is going to lay out a case where they're going to say Derek Chauvin used excessive force. He kept his knee on the throat for far too long. He didn't need to have his knee in his throat to begin with because he was already subdued, he was handcuffed, he was on the ground. They're going to lay out a very strong case for excessive force and the fact that he had his knee on the throat caused the death. The defense is going to use this medical history to say, those things happened, but that's not what caused his death. Look at this coroner's report. The coroner's report clearly says he had these medical issues, he was high on drugs that he shouldn't have been using with these medical issues, and they're going to bring an expert to testify about this. To answer your question, we don't get to draw that line. It's the jury who answers that question. The jury is going to look at those two arguments and decide, was it the knee or his actions that caused his death, or could it have been a heart attack caused by using a stimulant when you have clogged arteries? So that the answer is it's the jury's decision.
See, if I was the defendant's attorney for Chauvin, and I'm assuming they have this because we don't have the witness list, at least not that I know of, I would find a doctor somewhere, and you can pay enough money to find one, that would come in and take the coroner's report apart and say, that may be true, but it's also equally possible that he died from a heart attack. And what I've read in the paper is that he had a lethal dose of fentanyl in his system. If that's true, okay, then you argue he died from fentanyl, ladies and gentlemen, as much as lack of oxygen, okay? And what I found disconcerting in this case when it started, the very first day the coroner's report was in the paper, it listed fentanyl and methamphetamines as found in the decedent's body. The very next day, all the social media outlets no longer referenced methamphetamines and fentanyl. It was simply not in the articles. They didn't want to see it, they didn't want to hear it, so they just took it out. It finally came back about a month ago or a month and a half ago when the trial came up. Oh, by the way, there's fentanyl and meth in this system. But it's absent for about 6 months.
All right. Any other questions in the audience? All right, we have one more online question, if you guys would like to take that, which is, what do you think the impact of COVID and, wearing masks in the trial and other things might have on the ability for the prosecutor and the defense attorney to read the jury?
I think it will be very instrumental. I think there's a lot of communication that is given by a person's just facial expressions. I think it'll be more difficult to tailor arguments during the middle of the trial based upon how you can see the jury is reacting to specific evidence. So I think that it will really matter. I think it might also matter because those jurors probably aren't going to interact with each other as much either prior to actually going into the jury room. And when they get there, I guess I don't know what exactly it looks like, but I suspect it's going to be a big room like this. And there's a lot of communication that occurs just by by your body, by being close to somebody. So I think it will have a huge impact on this.
One of the speakers from St. Thomas recently, one of the professors made the comment that when lawyers cannot watch the body language of jurors and witnesses, especially if they're wearing masks, if they cannot see their facial expressions, it has a huge impact on the attorneys not knowing what the jurors find interesting and relevant as opposed to boring and can we go to lunch now? Okay, and that I think is critical if you follow and watch facial expressions, which the FBI is very good at, and how body language can tell the lawyers what the jurors found interesting, what they found boring and unimportant. You then tailor your case as you can watch these people who are bored silly saying, they don't like this, I gotta move on. Or it's very important and they're all writing notes. Those are the things you're not gonna see, and I think that's gonna be very, very difficult for the lawyers.
One other question that we have, I think we have a couple minutes to do it, is now we didn't even talk about this, but the Derek Chauvin, originally it was the 4 police officers who were charged together. And then Derek Chauvin's trial was separated from the others. So the question is, if Derek Chauvin is acquitted, what will be the impact on the other cases?
Go ahead.
Well, it's certainly going to make it easier for the attorneys for the other defendants to lay out their case, because they're going to have a roadmap. They're going to know what the facts are that need to be brought out. But most importantly, they can point to the guy who is the most responsible and say, he's innocent. How is my client not innocent? And so it will have a huge impact on the outcome of their trial. The flip side of that is if Derek Chauvin were to be convicted on 1 or 2 or maybe all 3 charges, like Mr. Birkholz said, I don't see it happening that he's convicted on all 3. But if he's convicted on any of them, that will also have an impact on their trials. And it won't just impact their trials, it'll impact everything that happens in between. It'll impact future negotiations, potential plea deals. If he's found completely innocent, the state's not going to want to have 4 people found completely innocent. They're going to find a way to get a plea deal made that someone gets punished. It might not be the punishment that this group wants or that group thinks is appropriate, but someone will have to be punished, but they're going to make a pretty good deal that would likely result in no prison time now.
All right.
So.
Any additional thoughts or any additional questions that you guys might have? Anybody online? I think we got to them all. Well, we are out of time, but I want to thank you for joining us tonight, and thank you so much to our presenters for their time and their experience on this issue. We hope that you as an audience feel better informed about the criminal trial process and about this specific trial in general. And thanks again for everyone joining us online virtually. We greatly appreciate the time, and we thank you from Bethany Lutheran College and the Legal Studies program. Have a wonderful evening.